audience, welcome to HETV program titled Zeidman Software Forensics and Safe on IP. Today, we are very honored to have the creator for this field, software forensics, Mr. Zeidman, to share the essence of software forensics, which is the science of analyzing software source code or binary code to determine whether intellectual property infringement or theft occur. Mr. Zeidman has developed the algorithms, technology, and procedure for code sweep, which has been used in over 100 cases worldwide. Mr. Zeidman has been a consultant and testifying expert on over 250 cases involving billions of dollars of intellectual property rights. Mr. Zeidman is the president and founder of Zeidman Consulting that provide engineering consultancy to law firms regarding intellectual property disputes. And he is also the president and founder of Software Analysis Forensics Engineering Corporation, SAF, which is the leading provider of software intellectual property analysis tools. He's also the author of the book titled The Software IP Detective Handbook, Measurement, Comparison, and Infringement Detection. Let's welcome Mr. Zeidman.
Hi, Mei-Hsin. Thank you very much for having me. I'm honored to be here.
Mr. Zeidman, you have been the expert witness for many leading companies like Facebook, Texas Instruments, and involving many legendary cases such as Motorola Mobility, Google versus Microsoft, which involved the patent infringement on voicemail and graphic software, etc. Would you mind sharing your experience on this expert witness subject?
Over the years, I've had a lot of cases that have been interesting, and I figured I would just tell you a few of them, not in a lot of detail, but just tell you some of the things that have happened over the years that I find interesting. So the first one I call the case of the Overconfident Defendant. What happened is I was working for a plaintiff who was suing some programming contractors who had created software for my client and then gone away from my client, left my client, and started working on their own software that competed with my client's program. And they seem to have completed their competitive program very quickly and were now taking business away from my client. So my client sued them, and they hired me to look into it. And the defendant, these programmers, were very confident, and they basically said that I could come to their location and I could examine their computer to see if I could find copying, because they said they didn't copy, and therefore they were confident that I wouldn't find anything. At that point, my tool Code Suite wasn't very well known, so I don't think they'd heard of it and didn't realize that I had the ability to do comparisons very quickly. So they only gave me one day. I had to fly across the US to get to their location. I hooked up their hard drive to my computer along with my client's drive. Both had each party's software, ran Code Suite, and they stood around basically very relaxed, confident again that I wouldn't find anything. And also, they, as I said, they only gave me, I think, 4 hours to review the code, which wouldn't normally be enough without my tool, but because I had my tool, I could do it. And the results are very interesting because what I found was they had done a great job of scrubbing the code to eliminate any signs of copying. What they forgot to do was they forgot to look at the installer. So I actually looked at the installer code, which is the code that installs the program on the system. It was a Windows system, and the installer tells the operating system where to install the code. And lo and behold, the place where the code was being installed was not under their company's folder, but was under a folder with the name of my client's company. What they had done is they had gone through and scrubbed the code of any references to my client, but they forgot to look at the installer. So when it installed the code, it installed it in the folder reserved for my client's code. Needless to say, I wrote a report and the case settled very quickly when the defendants admitted that they had copied the code. Another case involving an interesting defendant was a time that I worked for a defendant in a code copying case. And the defendant gave me the code to compare. So I compared the defendant's code to the plaintiff's code, and I found no signs of copying, but then I also noticed that something didn't seem right about the code that my own client had given me. So I discussed it with them, and they went back to their engineers and said, "Oh, we accidentally gave you the wrong code. Here's the correct code." So I now compared the correct code to the plaintiff's code. Still didn't find any signs of copying, but again, looking through the code, something didn't seem right. I think the dates or the functionality. And so I went back to my client and I said, "I didn't find signs of copying, but this again doesn't look like the right code." Well, it turns out that wasn't the right code either. This went back and forth several times, and the final result was that my defendant was not guilty of copying code, but it took much longer and much more time than it should have. Now, I find this is actually a common problem, because whenever I work for either a plaintiff or a defendant, the engineers at the company sometimes don't understand the significance of the litigation. They don't understand that the entire company could be at risk. And they're paid to develop code. The programmers are paid to develop code, not to work on a litigation. So unfortunately, sometimes the programmers and the engineers and even the managers at a company aren't as cooperative with me as I think they should be, because they don't understand the importance. So nowadays, when I take on a case, I always tell the client to make sure that everyone working at the company knows how important this case is, and they need to drop everything to help me when I need help. I've also had a lot of experiences with experts, interesting experts. So one case, actually this is many cases, but the first time it happened, I was surprised. It's happened a lot since then, unfortunately, and I call it the case of the Gullible Expert. And what that is an expert will rely on the people at the company, like the CEO, to tell them what the results are. I see this most often with plaintiffs in a copyright case or a trade secret case, because the expert, rather than doing an analysis of the code, which may turn up nothing, the expert talks with the CEO of the company, and the expert report ends up being, "I talked with the CEO and he told me that there's no way these people could have finished the code, finished their program in that amount of time unless they had stolen the code." And the expert will say things like, "I talked to the vice president of engineering who says that he knows that nobody knows as much code as he does, and nobody programs as fast as his team does, therefore they must have stolen the code." And as you know, this is, or as I hope you know, this is not an expert's job. An expert the expert's job is to make a technical analysis of the code, not to rely on people who obviously have a stake in which way the results go. And of course, the CEO and the employees of the plaintiff have a stake, and the CEO and the employees of the defendant company have a stake. An expert is supposed to be independent. I've even seen one case some years ago where the argument by the plaintiff in a trade secret case was this, and this was echoed by the expert in his report. "We had a meeting with the defendant's team of programmers, and one of the programmers got up to go to the bathroom, and he walked through the lab, and on the lab there was a whiteboard that had a block diagram of the architecture of our software, and he saw it, and that's our trade secret, and the whiteboard was erased, and we don't have any proof that he saw it or even went to the bathroom, but our team remembers that he went to the bathroom, remembered that he looked at the whiteboard, and that's our trade secret." And then the expert echoed that. That's not even reliable testimony, much less expert witness work. Expert witness work must be a technical analysis, not someone at the company telling you what they think. There's another case I've run into again a few times that I call the case of the insane expert. In particular, there's one expert that I know who is sometimes on the opposite side as me. What I find is when he doesn't have a technical argument, he will just say somewhat random things, but he'll use lots of technical terms so that the lawyers really don't understand, and I don't understand what he's talking about. But what's worse is at a deposition, he will mostly remain silent or answer the wrong questions. If you ask him what kind of microprocessor is used in the device, for example, he'll say that the device has lots of resistors and transistors. And that's not an answer to the question. It's a way of avoiding the question typically because he knows that his client is in the wrong. And I once, actually twice, 2 times, this particular expert gave depositions. And 2 different attorneys came to me afterwards and they said, "You know this expert, right?" And I said, "Yes, I've known him for years." Then they paused and they said, "Does he have a mental problem? Is there something wrong with him?" And I said, "I don't think so. Why?" And they said, "Because he took 2 or 3 or 4 minutes to answer every question, and his answers had nothing to do with the question I asked." Now again, this kind of strategy, I don't like it. It works to delay a case, but if you get to court, you have to answer the questions. So the only thing this does is delay a case and cause both parties to spend money without getting to the truth. I guess it's a strategy that some experts will use or that some lawyers like. I don't. The only thing I can say is it's strange and interesting, but you won't win your case that way. And then finally, one of the more interesting experiences I've had with an expert was what I call the case of the proud expert. This was a patent case. I was representing a very small company that was suing a very, very, very large company, a very large technical, high-tech company for patent infringement. And the large company, the defendant, had hired an expert who had degrees from MIT and Stanford University. He had worked for years in different large high-tech companies. He'd been the vice president of engineering for a high-tech company. He'd written papers, he had patents. Very, very experienced person with a very impressive resume. He had brought up some prior art that he felt invalidated my client's patent. And he brought up a number of patents, prior art patents, and I found arguments for all the patents except for one. And I went to the lawyer for my client and I said, "One of these patents looks really, really good. It was issued more than a year before my client's patent, and it looks to do the same exact thing, which means that my client's patent is not valid." So the lawyer and I spent some time working on the patent, examining the patent specification. And then at one point we realized that the prior art patent didn't work. It was wrong. Even though it described what my client's patent was doing, it had an incorrect description. In fact, it had a circuit that couldn't possibly work. The reason is the circuit had 2 points. There were 2 points in the circuit that had to have different voltages at one point in time. But these 2 points, if you trace them, were actually connected together. You had to trace them through the circuit, but these 2 points with different voltages had to be connected together. And anyone who knows basic electronics, and I mean very basic electronics, a single point on a wire can only have a single voltage, not 2 voltages. So we went into this other expert's deposition knowing this crucial fact that the prior art didn't work and therefore couldn't be used to invalidate my client's patent. Now my lawyer knew a lot of technology. My client's lawyer knew a lot of technology. And he went into this deposition against this incredibly impressive expert. And I was in the room. And he said to the expert, this circuit doesn't work. He showed him the circuit in the prior art patent. And the expert said, oh, yes, it does work. And the lawyer said, well, if you could just educate me about this, I'd like to see how this works. So the expert took a pencil and paper and started drawing the circuit and writing down voltages. And at some point, the lawyer for my client said, but how can these two points have different voltages when they're connected together like this? And he showed him where they were connected. And instead of the expert saying what he should have said, which is, oh, this looks like something's wrong, I need to examine it again, he said, no, this works. I have a degree from MIT and from Stanford, and you're a lawyer. I know more than you do. I've been working in this field for several years. Let me show you how it works. And then he spent another maybe 5 or 10 minutes trying to make it work. And the lawyer said, it doesn't work, does it? And the expert said, look, young man, I have much more experience than you, and I know that it works. And the lawyer said, I respect you, sir, but I don't see how it works. The examiner started again going through a description. He said, well, it depends on what polarity the voltages are. If this voltage is positive and this other one is negative, and he spent another 10 minutes explaining it and not being able to show it working. And the lawyer said, these points are connected together. If one is positive and one is negative, how can you connect them together and get, without them causing a short circuit? This went on for about an hour before the expert finally said, and the expert was getting very visibly angry and upset and talking back to the lawyer, which is not something I recommend at a deposition, which is being filmed, which could be shown in court to the jury. Finally, the expert said, well, the lawyers wrote this report. I just signed it. And then he got up and left. What I can tell you is, shortly after that, we settled our patent case against this big tech company, and the big tech company paid my client a lot of money. They had made a big mistake with their expert. Their expert had ruined the case for them. But I got to witness it. I thought it was really funny, although I couldn't say it was funny, but very interesting, and it's not the proper behavior for an expert, but certainly makes a good story.
Thank you, Mr. Zeidman, for your insight and wise advisement. See you on our next program. And dear audience, please do come back next Wednesday at 1 p.m. for Zeidman Software Forensics and SEF on IP and HGTV. Do not miss the opportunity to sharpen your skill and enhance your proficiency for career competence.